All rise. The Honorable Presiding Judge and the judges of the Court of Appeals in the state of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state. It's all the court. You may be seated.
Good afternoon. I'm Judge Valerie Zachary. To my right is Judge Jefferson Griffin, and to my left is Judge Michael Staddy from the North Carolina Court of Appeals. I want to thank you all for inviting us to have a special session of the North Carolina Court of Appeals here in beautiful Nash County in your majestic courthouse. Judge Griffin has always spoken very highly of his home county, and we're very glad to be here. I'm going to yield now to Judge Griffin.
Thank you, Judge Zachary. Thank you to everybody here, all the court staff. Judge Wilson, thank you for your hospitality. Madam Clerk, she's in here. Thank you for your hospitality, and to our Sheriff Stone for making this possible for us. I had the great privilege and honor of growing up here in Nash County in Red Oak, and very excited to be here and hold court. We've had a couple opportunities to have visiting sessions, and I wanted to make sure that we had a priority. I cashed in a few chips to be able to come to make sure we got Nash County on the list, and fortunate to be here. So we're thankful for your hospitality again. Look forward to some great arguments here today and doing justice for the people of North Carolina. Thank you, Judge Zachary.
Thank you, Judge Griffin. We have two cases on the calendar today. We'll start with State versus Grant. Counsel, are you ready to proceed? Yes. Okay. Have you reserved rebuttal time? Do you know how much?
I was just waiting for the podium. I'm sorry, guys. Yes, I would like to reserve 6 minutes of my time.
6 minutes?
And I do have a stopwatch on my clock. I didn't see a clock here, so.
We don't have one here like we usually do at the Court of Appeals, and so Judge Griffin is going to keep track on his phone as well.
Okay.
We'll try to alert you when you're getting, if you run into your time.
Good afternoon. May it please the court, I'm Sharon Smith on behalf of Appellant Rashawn Grant. On September 29, 2022, Mr. Grant was convicted of first-degree murder for the shooting of Namir Davis in Edgerton County. He was sentenced to life in prison without the possibility of parole. Prior to his conviction, Mr. Grant was a law-abiding citizen. He had no criminal record, he had a young family, he had a very good job managing the Rocky Mountain Event Center. So Mr. Grant has raised 4 claims for relief on this appeal. Insufficient evidence to overcome his motion to dismiss the murder charge, insufficient evidence to support the acting in concert instructions, grossly improper closing arguments by the prosecution, and ineffective assistance of trial counsel. The first 2 claims boil down to a failure of the state's evidence. I will focus on these claims today, and invite any questions you may have about the closing argument and IAC claims. Namir Davis was shot during a gun battle at St. Francis Court, which is a cul-de-sac of apartments in South Rocky Mountain. It happened early Sunday morning, September 1st, 2019. Multiple guns and multiple shooters were involved. There were numerous witnesses at the scene. At the trial, the prosecution presented no eyewitnesses, fingerprints, DNA evidence, firearm evidence, text messages, voicemails, or any other evidence linking Mr. Grant to the shooting. The prosecution's case against Mr. Grant was built on conjecture. There are just too many holes. The state's case was essentially built on 3 pieces of evidence, none of which tie him to the shooting. First, police found Mr. Grant's cell phone in the parking lot of St. Francis Court. However, there was no evidence to show when or how the phone got there. The phone itself was not tested for gunshot residue, so there was nothing tying it to the shooting. Second, Mr. Grant bought a shotgun with his friend Ahmed Hadid on the Friday evening before the shooting. According to Mr. Hadid, the shotgun was old and rusty. He did not even know if it fired, and he did not think it contained any shells when he sold it to Mr. Grant. Mr. Hadid had actually contacted Mr. Grant weeks before this about whether he wanted to buy the shotgun. Mr. Grant eventually did buy the shotgun on the Friday before the shooting. Police did no investigation to determine whether Mr. Grant purchased any shotgun shells between the time he bought the gun on Friday and the shooting on Sunday morning. As we know, Rocky Mount's not a huge place. There's not unlimited places where you can buy ammunition. Third, from Mr. Grant's phone, we know he texted Ahmed Hadi at 2:25 a.m. on Sunday morning that he was going to his brother's house on Leggett Road to check on him because he was being harassed by Tony Agate. What happened after that is anyone's guess. There's simply no evidence that Mr. Grant got together with 3 or 4 other men, as the state contended, put on masks, and attacked the crowd at St. Francis Court. These 3 facts may have raised a suspicion that Mr. Grant was involved in the shooting, but nothing more. They do not amount to substantial evidence sufficient to overcome a motion to dismiss. What else came out of the trial? So we know there were a lot of witnesses at the scene. The first responder, Officer Sharon, testified there was at least 10 people there when he arrived. And his body cam confirms that. Footage confirms that. The lead detective on the scene described the scene as chaotic, with lots of people moving around. However, only one eyewitness testified at trial, Tony Agate. Agate and Mr. Grant's younger brother, Tyron Martin, were engaged in a beef over Facebook Messenger that started Friday afternoon, August 30th, 2019. Agate made threats to beat Mr. Martin up, even showing up at his apartment hours before the shooting. So Agate gave 5 different statements to police, none of them implicating Mr. Grant in the shooting. Agate, who was the presumed target of the attack, first said he didn't see the shooters, but later said he saw 4 gunmen, 3 wearing masks and 1 with no mask. Days after the shooting, Agate went on Facebook and claimed he knew who was responsible for Davis's death. But he told police he would have recognized if Mr. Martin or Mr. Grant were among the shooters, but he did not believe they were involved. Agate did not identify Mr. Grant at trial as one of the gunmen. The state also called Katina Horn to testify at trial. She was at St. Francis Court when the gun battle took place, and she did not actually see the shooting. She testified that she saw several cars leave St. Francis Court immediately after the shooting. About 5 minutes later, after leaving St. Francis Court and then returning, she saw a suspicious car leaving the area. It was a dark-colored Challenger or Camaro.
So is it your position that there wasn't enough circumstantial evidence
Yes, Your Honor.
to survive a motion to dismiss?
Absolutely.
I mean, what about the cell phone being right there? His
We don't know
cell
when it
phone.
happened. We don't know when it was put there. And we don't have any timing on that.
Was there a GPS tracker on it?
The GPS on the phone was set to arrive at St. Francis Court at 3 a.m. However, the state did not present any evidence to confirm when the shooting occurred. So we know that the shooting, the first responder who got the alert 41 seconds after 3 a.m. That's all the timing we know. We didn't have any shot spotter report, we didn't have a CAT report, we didn't have the 911 call actually showing when the shooting occurred. So we don't know if, he may well have, if he had his phone, which we don't even know that for sure, but assuming he did, he could well have arrived after the shooting. There's nothing tying the phone to the shooting. And we know there were lots of people out there that night.
Isn't it proper for jurors to make inferences from circumstantial evidence?
Right, but they have to be reasonable inferences. I mean, you have to have substantial evidence supporting those reasonable inferences. They cannot just be a guess or conjecture based on the suspicion, and that's what we have here.
Were there any shell casings around the scene?
Yeah, so they found actually 19 rounds of shots were fired. They found, 18 shell casings from handguns. Some were 9mm, some were .45 caliber. They found 1 shotgun shell. And that shotgun shell was a slug type shell, which is different than the pellet style that you normally have. The police had this shell for a couple of years before trial, but they only sent it for DNA testing a couple months before the trial, so there weren't any results available. So there was nothing tying that shotgun shell to Mr. Grant or the shotgun he purchased from his friend. You know, even though they had the evidence, they just failed to get it tested.
Was there evidence in the record about how far the shotgun shell hole was from his cell phone?
There was testimony by Detective Talley that it was found about 2.5 feet from the phone. However, we know that the officer who found the phone, Officer Judd, testified he didn't see any other items of evidence when he found the phone. So if it were right there, you'd think he would have seen it. However, there was testimony that it was found in the area.
What was the gauge of the shell, the
It was,
casing?
12 gauge.
And what was the gauge of the gun that was purchased? Is that also 12?
I don't know. I don't think there was any evidence about that.
Well, since the fact that the state proceeded under the theory of acting in concert change the whole calculus here?
It does, and that's our second claim, which is that there was nothing to support that instruction. So we have two witnesses. We have Tony A. Bennett saying he saw 4 gunmen, 3 masked, 1 unmasked. He did not identify Mr. Grant as any of those, though he said he would have recognized him. We also have Bettina Horn, who sees this mysterious dark-colored car leaving the scene. She follows it to the apartment complex nearby and sees 4 masked men get out of the car and scatter in different directions. Then the driver who was still in the car drove off. So that's what we have as far as there being multiple people involved. But there's nothing tying Mr. Grant to any of those people. Those people were never identified. The car was never identified. We don't know whose it was. It wasn't Mr. Grant's car. So there was actually nothing substantive showing that Mr. Grant entered into a common plan or purpose with anyone to commit this crime.
Did Mr. Grant make any communications directly before or after when we think the shooting probably took place?
Right, so the police had his phone, so they had access to all his text messages, phone calls, everything. We know that his brother had been trying to call him earlier that evening around midnight. There was no answer. Then Abed Hadi, his friend, texted him about 1 o'clock and said, "What are you doing?" Mr. Grant did not respond until 2:25 when he said, "I've been knocked out, maybe asleep. I just woke up. They're harassing my brother. I'm headed over to his apartment to check on him." And by heading over there, he meant to his apartment on Leggett Road, not to St. Francis Court, because I think that was somewhat confused in the state's brief. These are several places. So that's all we know is that Mr. Grant woke up, saw that something was going on, and was headed over to his brother's apartment. And this was about 2:25, 2:30 a.m.
Didn't the men that engaged in the shooting, didn't they act together as they did that?
Well, there absolutely is evidence. I mean, they were masked, presumably they were together because they were seen fleeing the scene in the same car. So there's evidence that someone was acting in concert, but there's no evidence tying Mr. Grant to any of those people. I mean, the state doesn't know who they were. They didn't offer any evidence at the trial who these people were. They
Is that a necessary requirement for acting in concert instruction?
Well, but you have to show the common plan and purpose between Mr. Grant and the individual.
Can't action show common plan or purpose?
Absolutely, but you have to have some tie between Mr. Grant and another person. This is just conjecture. We don't know. There's nothing in his phone, nothing in his messages to show that he, got together and said, "I'll meet up with you guys, and we're going to head over there."
Did Mr. Avent testify they were all firing at cars and people, though? Is that correct?
Right. And he said that the man with the shotgun was actually aiming at him and hit Mr. Davis instead.
So if I understand correctly, please correct me if I'm wrong, you're saying the fact that his gun was there, defendant's gun was there, defendant's cell phone was there, and then a shotgun was used, and he had bought a shotgun. And his brother, he was trying to defend his brother, so there's some kind of motive there. That circumstantial evidence is not sufficient.
Right.
That would not rise above conjecture and speculation.
Right. If you look at the cases, we cited a number of cases, and the state cited cases, they're all fact specific. So when you look at the cases that we cited, even that the case cited, there was a lot more evidence than we have here. Especially the ones that the case cited, there's a case, the Dover case out of the Supreme Court. And in that case, they said circumstantial evidence is fine. You don't have to have any direct evidence. But when you look at the evidence in that case, there was a lot more evidence than there was here, including that the defendant in that case had told made false statements to police about his whereabouts. He also tried to erase his phone history off his phone. So there was more than just motive and maybe opportunity. And that's not enough to get past permission.
Well, and here, I mean, didn't the state produce some evidence of means as well? I mean, it's not just motive and opportunity, is it? Didn't the state produce some evidence of means
No.
by purchasing the shotgun?
Well, I mean, the shotgun was never tied, I mean, we don't have the shotgun, it was never tied to this crime, so there's nothing, you know, it's just a guess that that shotgun was used, a pure guess, pure deduction. There's no evidence to support that. And we have Tony Aiken, he's the eyewitness, he was there, he saw the shooters. He goes on Facebook and says, I know who did it. He had the opportunity at trial, sitting across from Mr. Grant to say that was him, and he said no. You know, he did not identify him. So we have to go off what their evidence is. Their
I don't think
evidence-
that's a significant circumstantial fact, though, that he purchased the shotgun in such close time to when this happened.
Well, it was on Friday evening, this happened Sunday morning. So yeah, his brother was being threatened. I mean, that's not an unreasonable, I mean, you know, by somebody with a very bad reputation and felony conviction. So that's not an unreasonable, you know, reason to buy a shotgun. You know, he could have been buying it for his brother to have for self-defense. He could have been buying it for his mother who lived with his brother, who's also being threatened. So we don't know why he purchased the shotgun. We don't know what happened to the shotgun after he purchased it. There's absolutely no evidence of that. There's nothing to put that shotgun in his hands the night of the shooting, or even put him involved in the shooting at all. It's just, you know, the state had some evidence. They had his cell phone. They knew, you know, from his cell phone they saw he bought this gun. So they made up a story to try to, you know, tie all his pieces together, but it's just a story. There's nothing to back it up. It's just, you know, facts that alone look suspicious, can raise suspicion, but there's nothing more than a suspicion. There's no proof whatsoever that Mr. Grant was involved. The shooting was part of a group of 4 to 5 masked men. You know, any relationship to this Challenger or Camaro that was seen leaving the scene. And the police, you know, they had an opportunity. They could have done some investigation. They could have looked to see if he purchased any shotgun shells. They didn't. They didn't even search for this car or these men that were seen fleeing the scene. So there was a real failure of the investigation here too. I mean, I don't know what else I can say except, you know, there was, you know, like I said, there were some facts the state had, and then they made up this story to go with it. But, you know, we have Tony Aban, who was that witness and presumed target of the tax state. I think if I had been someone who lived in that apartment complex, set me up, because the people just seemed to know it too well. So he didn't, you know, he would say, I think it's somebody else. And he's the one eyewitness they had. I mean, they had a bunch of people out there. Another man was shot. He didn't even testify at trial. So that charge had to be dismissed. You know, unfortunately, they just didn't get cooperation from the many witnesses that were out there. But, you know, the one they did said basically it wasn't Mr. Grant. And that's not disputed. You know, as far as the acting in concert instruction, we know that there has to be evidence of a common plan or purpose shared by the accused with at least one other person. So, you know, perhaps we don't have to know that person's name, but we have to know what the connection is. Otherwise, you're just guessing, okay? You know, so we know Mr. Grant was asleep until 2:25 a.m. The state says the shooting happened around 3 a.m. So when does he get together with these 4 or 5 other people and get masked and plan the shooting? We don't have anything.
I'm sorry, how do we know he's asleep at 2:25?
I'm sorry.
How do we know he's asleep at 2:25?
Because that's when so Mr. Hadid, his friend, had texted him at 1 saying, what are you doing? At 2:25, Mr. Grant responded to say, hey, I've been knocked out.
Okay,
I'm
but
not
he didn't testify to that, that's just what you're saying.
That was on his phone, that was a text message.
Right, so you don't know what I'm knocked out means.
Well, it makes sense that he was asleep because his brother had been trying to call him, he didn't answer any of his calls. I mean, there's no other.
I understand what your interpretation is, but that, we don't know, he didn't testify that that's what it meant or anything. So
No, but we have his text message, I mean, I think that's as good as the test, probably better than this point.
When you say I'm knocked out, could mean I'm knocked out of a fight?
He said, I'm up now, I was knocked out, I'm up now. I mean, I think that's the only reasonable interpretation of me make from that. So they happened at that time, so I think it's better evidence than even testimony. So, you know, like I said, we don't have any evidence that Mr. Grant entered into a contract with anyone to stage this attack. So there was no basis for the trial court to submit that instruction. And if they had not submitted that instruction, there was no way Mr. Grant would have been convicted. We know section 15A, 1443, sets forth the standard for prejudice when you have something like a unsupported jury instruction. Under that prejudice standard, prejudice occurs when there's a reasonable possibility, that had the area in question not been committed, a different result would have been reached at trial. So we have the only two witnesses that were there, Tony Avent and Tina Horn, saying they saw 4 to 5 men, you know, wearing masks. Then we have Mr. Grant, who doesn't have anything on his phone, saying, you know, I'll meet you I'm going to meet you somewhere. And we know these days everything's on their phone. I mean, so all we have is him at 2:25 saying he's headed over to check on his brother because Avent was harassing him. That does not equal a plan to go attack St. Francis Court with multiple guns and multiple people.
Would you, excuse me, would your argument for this defendant be different if they had found his driver's license lying on the road instead of his cell phone?
Not necessarily. I mean, like I said, there were multiple people out there. There were lots of people out there. And we don't know when the cell phone was there or driver's license. You know, it could have been equally possible that he got there, the shooting had just happened, he saw what was happening, and he left, and he dropped his phone or driver's license. So unless we know when exactly he was left there. And the state, I think on purpose, did not present evidence to show when this shooting happened. And I think that was a conscious decision. Because they had the GPS, 3 o'clock a.m., but, you know, that leaves 41 seconds for this 911 call, for the shooting to take place, the 911 call being made, the dispatcher to gather all the evidence, and then issue an alert. So it's very, very plausible that the shooting could happen before 3 a.m.
Well, but wasn't that an ETA of 3?
Right.
You know, which is estimated, so if they drove faster than the speed limit or...
But usually the GPS adjusts for your speed, so that's my experience. But, you know, I just think that there was a very specific reason the state did not present evidence to set when the shooting occurred, because they surely could have. And then, but they wanted to leave it wide open so they could argue, okay, his GPS was set for 3 a.m., the shooting happened right at 3 a.m., but there's nothing to support that. We don't have any timing evidence about when the shooting actually occurred.
Yeah, 3 minutes. Till you hit your 6.
Till you hit your rebuttal.
Yeah, you got 3 minutes before your rebuttal time.
Okay. So, as far as the closing argument, I'll just touch on that quickly. So the prosecution, again, there were so many holes in their case. The prosecution really had to use their closing argument to tie this together. And they went way outside the bounds of privacy doing that. Probably the worst offense was commenting on Mr. Grant's silence before he was arrested. State versus Boston says pre-arrest silence is protected under the Fifth Amendment. It can only be used for impeachment purposes. So that's if the defendant testifies. Mr. Grant didn't testify. There was no proper use for the state to be commenting on the silence. And there was no evidence that he was evading the police. he did speak to the police. They searched his home, they searched his car, they couldn't find any evidence. So, that itself is just so grossly improper that it felt like we had to bring that claim. If you have more questions, I'll do the rest of my
Good.
Okay, thank you very much.
Thank you.
You may proceed.
May it please the court, my name is Kaylee Chozak, and I'm here with the North Carolina Department of Justice on behalf of the state in this case. I'd like to take a moment to thank Alvin Keller. He is sitting at council table with me and actually wrote the briefs in this case, but has graciously allowed me to argue on his behalf. Now, obviously, as the court is aware, the defendant appellant in today's case raised 4 issues about from trial, but given the complexity of the facts of this case, if the court will allow, I'd like to start by summarizing the facts and the evidence as it stands before us. So what happened on the early morning of September 1st, 2019 actually started 2 days prior on August 30th, 2019 in the afternoon when Tyrone Martin hit Tiffany Henderson while on FaceTime with her brother Anthony Horn. Now, this action sparked Henderson to go home and to see her brother, and then Henderson and Horn went to try to find Martin later that afternoon. They went both to his house and to his work. And at the same time that they're looking for him, this is when Tony Avent, her cousin, starts messaging, sending threatening text messages over Facebook to Tyrone Martin. And these threats are not only against Martin, they're also against his mother, who lives with him at the time, and against his brother, who is the defendant appellant in this case, Rashawn Grant. And those messages include threats saying that Martin needs to either fight or get blowed out. Around the same time that he's sending these threatening messages, and Henderson and Horn are trying to find Martin at his house and at his work, Grant, Martin's brother, reaches out to his friend to ask to buy his shotgun. Now, defense counsel is right that multiple times, or previously before, multiple weeks before, his friend had offered to sell him the shotgun, but he hadn't officially bought it until he decided the same day that his brother starts getting threatened, that he needs to buy the shotgun. And he specifically tells his friend that he needs it ASAP, and he wants to know whether it has shells because he needs to make sure that that thing works. And shortly after he reaches out to his friend that afternoon, he then goes and buys the shotgun from him. Now the following day, August 31st, Avent continues threatening Martin and his family, and the threats escalate because Avent sends Martin his address of where he's staying, which is 116 St. Francis Court. And then after no response to that, Avent shows up outside of Martin's door around midnight in the early morning of September 1st, and he sends him a picture of his door. He's banging on his door. It's very clear that he's out there and that he's continued to threaten him up to this point. At the exact same time, these threatening messages, including the fact that he's outside of Martin's door, are being sent, Martin is calling his brother Grant. And he calls him multiple times, but Grant doesn't answer, and he also sends him multiple messages. But those messages aren't received to Grant until a few hours later, because it isn't until after 2 a.m. that he reads those text messages from his brother and supposedly sees those calls, and at the same time he texts his friend, the same friend that he bought the shotgun from, that his brother is being threatened, and so he's on his way over there. And so Grant goes over to his brother's house, and then the two of them, along with 2 other masked men, they all put on masks, and they go to 116 St. Francis Court, the same address that Avent had sent to Martin, and there's a shooting that occurs, and they're all shooting in the direction of Avent, which Avent is in Anthony Horn's car, which he testifies to, and he's with Anthony Horn and Amir Davis. And so they're all shooting in the direction of this car, which is why a majority of the bullets are found either embedded in the car or in that area. And Anthony Horn actually gets shot. And as we know, Namir Davis ends up getting killed in this moment. So when the police arrive shortly after the shooting, they find all of these they find all of the different bullet casings in that area, and they also find that Namir Davis is killed by a shotgun slug, the only shotgun slug that is found. And they also find Grant's cell phone in the middle of the parking lot. And the cell phone has 116 St. Francis Court plugged into it, showing the estimated arrival time as 3 a.m., but also that at 2:59 a.m., the GPS is showing that they were within 100 feet of 116 St. Francis Court. And they also find a few feet away from that from the cell phone, they find a shotgun shell, the only shotgun shell found in that parking lot. Now, considering all of this evidence...
So in your recitation there, I mean, I understand how we've been through the shell, the cell phone, but I guess, is that just your view of the evidence, the recitation of them getting in the car together and going together? Would that actually come out in the trial anywhere? Did anybody testify to that in the record?
Your Honor, at this stage, reviewing especially the first two issues, the motion to dismiss and the jury instruction on concert and action, that this court should take the evidence in the light most favorable to the state. And so this is the state's view of the evidence. And given the fact that the cell phone was found there with the address plugged in, the address that his brother had received, and it's clear that he was going to his brother's house, the evidence does show that him and his brother went there with two other men, and they were the ones who participated in this shooting.
Is clear, or a reasonable inference could be made that
Your Honor, this supports a juror could reasonably infer from this information, from this evidence, that is what happened. And that's exactly what the jury did in this case. And that's what the standard is before us now as to the first issue. Because the court must determine whether there was substantial evidence to show that the defendant in this case was actually the perpetrator of the crime. And the North Carolina Supreme Court has made it clear in this court that the same weight should be given to circumstantial evidence as to direct evidence. And when it comes to trying to identify the perpetrator, as Your Honors mentioned earlier, it's important to look at not only the motive and the opportunity, but also the capability. And if there is sufficient evidence of those three things, then it's very clear that there is substantial evidence.
Under the acting in concert theory, did the state have to show that he was actually the one who killed the victim?
No, Your Honor. Under that theory, it only matters that one, the Grant was present at the scene, and two, that he was acting with others in pursuit of this common purpose. And again, on that, the court should review that, viewing the evidence in the light most favorable to the state. And as the Grant stated earlier, that there was clear evidence that they all did act together, that there were four men that clearly put on masks together. They were all shooting in the direction of Avent and the car that he was in. And that's also shown by both Avent's testimony and Katina Horn, that there were all these masked men that both came together and left the scene together, which is sufficient to show that there were men acting in concert. And the fact that Grant's cell phone is found at the scene of the crime is significant, especially the fact that he was the one that address was plugged into his phone, because that shows that he was either the one driving or the one navigating or both. And so clearly, to some extent, he was a part of this plan, even if there's no other previous text message information showing that they had all discussed this. That's not necessary. What's clear is that he was there, and it's indicative of the fact that it's his phone that has the address plugged in, because he was a part of this group that was going and putting on the masks and shooting in the direction of Avent, eventually killing Namir Davis.
Well, how do you respond to the defendant's contention that although there may be circumstantial evidence that he was present at the scene, there's no evidence that he actually shot anybody?
Your Honor, under the theory of acting in concert, it doesn't matter whether or not he was the one who shot Namir Davis. What matters is that he was there and he was a part of the group that was involved in the shooting, because as I've stated, the fact that his phone is there with the GPS bringing him to that location, it shows that he was a part of this group, that he was traveling with them and also was even navigating the group in that direction. And so regardless of whether he was the one that actually shot Namir Davis, under this theory, the jury still reasonably found that he was acting in concert with the group in the shooting, and so he can be.
So what facts are you alleging or inferences that get us to see that he was acting in concert with these other people?
Well, first, Your Honor, the fact that he stated in the text message to his friend that he was headed over to his brother's house, and the fact that he had previously purchased this shotgun at the exact same time that his brother starts receiving threatening messages. Because, as I mentioned earlier, he had multiple weeks to purchase this shotgun from his friend, but it was not urgent until his brother began getting threatening messages. And then he's suddenly telling his friend he needs it ASAP, he needs to make sure it works, and he needs to know whether or not it has shells in it. And so the fact that he has that shotgun, and then he gets all these messages from his brother when his brother's being threatened, and he then says he's going to his brother's house, and then the fact that his cell phone is found at the scene with the address plugged in, the 116 St. Francis Court, which is the address that his brother would have had, not an address that we have any information that he had, but that once he went to his brother's house, his brother provided him with the address, and given all of the threatening messages that he had received from Evan saying that he needed to either fight or he was getting blown down in public, Evan also told him, "Can your mom stand her spot getting shot up every weekend?" Saying that he was intending to shoot down Martin's address because that's where his mother was staying with him. And so all of that evidence together shows that he was with this group as they went to go try to fight Evan, to shoot him, and that he was a part of that.
And so you're saying that the common plan or purpose was to go after Avant?
Yes, Your Honor. And that's why, as Avant testified, it seemed that he was being shot at, but Namir Davis, who was behind him, was the one who actually ended up getting shot and was killed. But it seems as if most of the bullets were headed in the direction of this car where Avant was in.
So your friend on the other side, so there's no fingerprint evidence or DNA evidence that the state was able to present, is that correct?
Yes, Your Honor. The state didn't have any evidence with respect to the shotgun specifically because they were never able to find the shotgun. They were not able to find it at Grant's home. But despite that, there is sufficient evidence given all the information relating to motive, opportunity, and capability. As mentioned previously, both the North Carolina Supreme Court and this court have consistently found there to be sufficient evidence, both to support the trial court's denial of a motion to dismiss, but also to support the acting in concert jury instruction. And here there is plenty of circumstantial evidence to show all three, motive, opportunity, and capability. The motive being the threatening text messages that his brother had received, not only threatening Martin, but also threatening his mom and Grant. And also the fact that he texted saying he was on his way to his brother's house. And the opportunity being his cell phone found there at the scene, showing that he was clearly there, he was clearly present, and that he had found his way there using that address. And the capability, the fact that he had bought a shotgun and was able to use that shotgun to shoot at Avant and ended up shooting Namir Davis. And so, given all of that, there is clearly sufficient evidence to support the trial court's denial of the motion to dismiss.
I have a factual question. In your brief, it said something about a rifle and a shotgun. Was there just a shotgun, or was there a rifle and a shotgun?
Your Honor, at the scene
Yes.
of the crime, they found multiple different guns.
Right.
There were handguns and there were casings from other handguns, but none of them were linked to Grant, but the shotgun itself was never found.
Okay, but there were casings.
Yes, there was only one shotgun shell found, but there were 18 other handguns found at the scene. If the court has no further questions on the first two issues, then I'll briefly touch on the third and fourth issues. With respect to the closing arguments, both the North Carolina Supreme Court and this court have repeatedly held that the standard is very high when closing arguments are not objected to. And the standard is that the statements made must be so grossly improper as to warrant the trial court's intervention. And there is a prejudice aspect as well, which states that if the trial was so infected with unfairness that the resulting conviction would have been a denial of due process, then that would warrant reversing. But here, none of the statements made are so grossly improper, such as to warrant that.
Or you can see they are improper?
No, Your Honor. With respect to the conversation with respect to the prosecutor's statements regarding whether or not the Grant came forward and provided this shotgun, which Grant alleges was a comment on pre-arrest silence. Considering the context of what those statements were made in, it's very clear that the prosecutor was trying to respond to what was defense counsel stating that the police, didn't look into the shotgun, didn't find the shotgun, couldn't have tested it, couldn't have tested didn't test the bullet. And so the statements that he makes in his closing argument, which is just a few sentences, is to say that they didn't find the shotgun and they couldn't test it because Grant never came forward with his shotgun. They could never find it when they were searching for it. And the North Carolina Supreme Court in Lloyd said that it's important to consider phrases, in closings on appeal in the context in which they're made. And so in that factual circumstances, given the fact that he's discussing whether or not he came forward with the shotgun, it's certainly not grossly improper for him to talk about whether or not they could have found the shotgun when he never provided his shotgun. And also, the defense cites Boston for this issue, but Boston specifically says that a proper invocation of the privilege against self-incrimination is protected from prosecutorial comment. But what happens in this case is Grant never made a proper invocation before his arrest as to being silent. He actually never really made any invocation because he does talk to the police, and defense puts that in their brief that he didn't actually even remain silent. He does speak with the police, and so Boston isn't necessarily even applicable in this case because what the prosecutor is talking about in his closing has nothing to do with the fact that he didn't necessarily talk to the police, and so it's not improper for him to bring that up in his closing statement because he didn't invoke the privilege against self-incrimination before he was arrested, and he wasn't even silent at that point. But if the court does believe that that was improper, then it certainly does not rise to the level of so grossly improper that it unfairly infected the trial. And with respect to the last issue, none of the arguments that defense raised with respect to ineffective assistance of counsel rise to the level under the Strickland test to show that counsel's performance was so deficient such that Grant was prejudiced in this case. And if the court does think that there may be some questions with respect to the decisions made by the trial counsel in this case, then it would be more appropriate for the court to not rule on the merits of that and to allow the grant to raise that in an MAR later, which the North Carolina Supreme Court made clear as an option in Long in 2001, because a lot of the decisions made involve trial strategy, and defense counsel was clearly present at trial. He objected many times. And so with respect to the issues that Grant raises, it may be more appropriate to let the lower court develop those evidentiary issues and consider that. The state, if the court has no further questions, then
I'm sorry.
the state respectfully asks that this court uphold the conviction.
Thank you. Do you have your rebuttal time on your phone?
I don't, I
Yeah, you got 7.5 minutes.
Thank you. So I just want to go into a few things that State argued. So we have gone way past a reasonable inference and saying the evidence showed that Grant got into a car, so we don't know what car. Grant's car was not seen at the scene with his brother, and went to St. Francis Court and shot him. Okay, so that is not a reasonable inference from any of the evidence that was presented in the trial. There was evidence that there was an unknown car, a dark Camaro or Challenger, which did not belong to Mr. Grant, there was no evidence that belonged to Mr. Martin, was seen fleeing the scene with a bunch of masked men inside. There is nothing to connect Mr. Grant to that car or to those other people. So that goes way past a reasonable inference into projection, pure projection.
So I tend to agree with you in that posture there up to that point, but I mean, don't you need to put on enough circumstantial evidence based on what you said with the cell phone, the circumstances around it, all the communications, the shotgun shell, the purchase of the shotgun, the cell phone GPS, presence, its proximity to the shotgun shell. I'm having a hard time not seeing how, and I'm listening to you, how that's not enough circumstantial evidence.
Well, I think you have to make a lot of leaps in logic to get that there was sufficient evidence that Mr. Grant, first of all, basically conspired with these other men. There's nothing to support that.
Well, you don't have to actually conspire to act in concert.
Enter into a common plan or purpose. I'm sorry, that was the wrong word. But there's absolutely no evidence of that. We don't have him communicating with anybody. We don't have him.
Do you have to actually communicate with the other people to act in concert?
I think in this case where you have them supposedly in the same car, all with masks on, there has to be some communication there.
But does the state have to show that? Or does the state just have to show that they acted together or in support of one another?
The state has to show Mr. Grant was one of the people who was acting in concert. And that's the problem we have here. We don't have him as, there's no evidence that he was one of those 4 people. In fact, we have the eyewitness they called saying he didn't think he was one of them. He would have recognized him. He went on Facebook and said he knew who was responsible. He had the opportunity in court to say to Mr. Grant he did.
Right, but isn't that, I mean, to your point there, isn't that a question of credibility for the jury at that point, whether they...
Sure, but there was no evidence that Mr. Grant was one of the shooters. There just was no evidence. Nobody said he was one of the shooters. There's a bunch of people out there that night. Nobody recognized him. Nobody saw his car.
Isn't that what the circumstantial evidence is? It's just, wouldn't a jury have to go through this logically and say, well, he just happened to buy a shotgun a couple of days before, and then a shotgun just happened to be used with this particular crime, and his phone just happened to go to this particular location where this person just happened to have a problem with the brother, and then...
Well, they do raise suspicions. There's no doubt about that. I mean, there's suspicious evidence here, and I know that's why the state brought this case. However, there's not enough. I mean, to take it beyond suspicion. I mean, if you add all those things together, you say, okay, maybe he was there. Maybe he was there when the shooting occurred, but we don't have any evidence he fired a weapon. We know there was lots of people there. So Nobody saw him there, nobody saw his car there. There's nothing connecting him to the shooting itself. So there's nothing connecting him to these other people that were seen there. So it's, I mean, just look, I was just going back over some of the cases that were cited.
Well, excuse me, but assuming that this is and without, I'm not saying this, but just assuming that this is a weak case, isn't there a preference for submitting this to a jury and letting a jury make that decision?
There is, Your Honor, but there is a standard. And I cited, I think, 7 cases in our brief where this court and the Fulton County Supreme Court said it doesn't get to that point. And I just want to talk a little bit about the main case the state relied on in its brief, which is State versus Dover. This is the 2022 case of the North County Supreme Court. So this was a close case. The Court of Appeals found that there wasn't enough evidence. The Supreme Court reversed that. So let's just talk about what the evidence they had here. So this was a close case. Let's see. So we have the defendant. Let's see. I'm sorry. Okay. So the defendant made conflicting statements to police. He was questioned. He told police he was at home. They got hold of his phone records and said, no, he wasn't at home that night. He was going around, he was buying drugs. He was close to the deceased's home. He went out to buy, like I said, buy drugs several times. He also deleted his call log and the text history from his cell phone. In addition to his conflicting statements and efforts to conceal evidence, the defendant had well-known money problems, was a drug addict, and frequently asked to borrow money from the deceased. The deceased was known to carry cash, and his wallet was missing from his home. After his arrest, the defendant instructed his girlfriend to retrieve $3,000 in cash from the bottom of the trash can near the defendant's home. The defendant worked with and knew the deceased, and there were no signs of forced entry in the deceased's home. The defendant made statements to the deceased's daughter indicating he knew the deceased was dead before the body was discovered.
Well, he didn't actually say he knew he was dead, as I recall in that case.
Well, he made statements indicating that he was gone. And that was
Yeah,
before the body.
didn't he say something more like, he's not coming back, or something? I mean,
Something like that.
he didn't say he was dead.
I don't think he was really dead, but it was suspicious, for sure. So that's a whole lot more evidence we have here. I mean, we had, okay, so it's legal to buy a shotgun. We don't know what purpose it was for, but his brother was being threatened by a thug, okay? And so that's not an unreasonable purpose to buy a shotgun. You know, if he was buying it to go kill Tammy Abed, why didn't he go out there Friday night? You know, that's when a lot of these threats were taking place. He didn't. He could have been buying it for his brother to have for self-defense, or his mother to have for self-defense. We don't know.
But, I mean, the fact that there's alternative theories of innocence does not mean that the state can't proceed with that and prevail with circumstantial evidence. Isn't that correct?
But there has to be a standard in that. It cannot be based on conjecture. And if it's just a suspicion, that's not enough. You have to have more than that. You have to have something connecting him to what happened out there, and we don't have anything. We have the fact that he may have been there, his cell phone was there. Cell phone doesn't mean he was there, okay? If we want to, confirm that he was there.
About a minute left.
I'm sorry.
You have about a minute left.
You have a minute.
Yeah, sorry.
Also, we have to remember that Mr. Grant was convicted of first-degree murders. That involves premeditation and deliberation, specific intent to kill. We don't have any evidence how this gun battle started. Tony Abed said he was fast asleep in a car. He heard gunshots. He got up, got out of the car. There was crossfire. There was many people shooting. We don't know exactly how it started. So how can you say there's premeditation and deliberation when somebody may finish shooting it, go out and shot back? So we don't have enough to establish premeditation and deliberation. As far as the closing arguments, the prosecutor wasn't talking about the shotgun. He would say, okay, say you're suspect in a murder case, wouldn't you want to just go ahead and clear it up by talking to the police? He said, Mr. Grant would talk to the police. If you were in a situation where, they're looking at you for a murder and you had nothing to do with it, you would think you'd come and talk to them and explain what's going on. That's a comment about silence, and it doesn't matter whether he invoked his right. That is a comment by the prosecutor. There's no basis for saying that. There's no, should have been testified. So not used for impeachment, it was completely improper statement by the prosecution. Thank you, Your Honor.
Thank you. Counsel, I want to thank you for your excellent arguments today in a very difficult case. We will take this matter under advisement.
Thank you.